the applicant and the state. The application for bail is a constitutional right, and as rightly stated by the prosecution, the discretion is for the judicial officer. The surety is presented, and my attention being drawn to surety number 1 and 2, not being within this court's jurisdiction. This court operates countrywide, and as such has jurisdiction by its unique status to try all matters within Uganda. Thus, the said sureties are within the court's jurisdiction. However, be it as it may, even the constitutional bail guidelines under Guideline 5, one of the considerations is that such sureties are resident within Uganda. In the premises, therefore, I find all the sureties substantial, and bail is hereby granted on the following conditions. They are accused to execute a cash bail of 10 million shillings, and each surety is bonded at a non-cash of 100 million shillings. And accused will return formation and fixing of the matter for a pre-trial on the 18th of October 2025 at 9 a.m. I so order. Balunywa, the applicant, is charged with 3 counts of abuse of office contrary to Section 10(1) of the Anti-Corruption Act. The applicant, through his counsel, Asman Matovu, and 5 other advocates, made an application seeking that the applicant, now on remand, be released on bail pending his trial. It was the submission of counsel for the applicant that the applicant has a permanent place of abode, and he is of advanced age of 69 years, and presented himself to court upon summons having been issued by this court. The applicant presented 4 sureties whose details are reflected on the court record. In addition, the applicant also presented his passport to be deposited in court and land title for land comprised in Block 24, Plot 1406 at Bukoyo, Iganga District in the names of the applicant as additional security. The prosecution, represented by Ms. Caroline Nabasa, an assistant DPP, and Ms. Immaculate Angutoko, a chief state attorney with the Office of the Director of Public Prosecution, opposed the bail application on the following grounds. It was the submission of the state that the accused is aged 69, yet all those presented as sureties are way too younger than the applicant to compel him to attend court. Notably was the 3rd surety, Mr. Ali Balunywa, a son to the accused. The applicant is charged on 3 counts, and he has another file that has been registered against him still on charges of abuse, that it was a challenge serving the accused with criminal summons, as his known telephone numbers were not reachable, and the officer who went to serve him at the residence was informed that the applicant was not home. Thus, the prosecution prayed that the sureties be found non-substantial. And rejoinder, Counsel Matovu submitted that it is this court's discretion to grant bail, and the constitutional bail guidelines practice directions give guidance on consideration for bail, and having gross counts does not take away the fact that the offenses are bailable offenses, and they are not capital in nature. But if the applicant were to bring sureties above his age, being 69 years, would mean bringing sureties that would be a burden to this court because of their advanced age. That the sureties presented are responsible citizens, close associates of the applicant, and they believe they shall compel him to attend court, the decision of this court. Bail applications under this court are governed by the Constitution of the Republic of Uganda 1995, the Magistrates Court Act, the High Court Anti-Corruption Division Case Management Rules 2021, and the Constitutional Bail Guidelines for the Courts of Judicature Practice Direction 2022. I have considered all that has been submitted by both the applicant's counsel and the prosecution in opposition of the bail application. The constitutional bail guidelines for courts of judicature practice directions implore the court to be guided by the following principles while considering a bail application under Guideline 5. The right of an applicant to be presumed innocent as provided for under Article 28, 3A of the Constitution. The applicant's right to liberty as provided for in Article 23 of the Constitution. The applicant's obligation to attend court. The discretion of the court to grant bail on such terms and conditions as the court considers reasonable. And the need to balance the rights of the applicant and the interests of justice. Guideline 13 thereunder also provides for consideration for bail. The court shall consider the following in handling bail applications: the gravity of the offense, the nature of the offense, the antecedents of the applicant so far as they are known, the possibility of a substantial delay of the trial, the applicant's age, physical and mental condition, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of the applicant to commit an offense while on bail, the likelihood of the applicant to interfere with witnesses, the safety of the applicant, the community, and the complainants, whether the applicant has a fixed place of abode within Uganda or whether he or she is ordinarily resident outside Uganda, whether the applicant has sufficient sureties within Uganda to undertake that the applicant shall comply with the conditions of his or her bail, whether the applicant has on a previous occasion when released on bail failed to comply with his or her bail terms, whether there are any other charges pending against the applicant, or whether the offense for which the applicant is charged involved violence. The applicant has shown that he has a fixed place of abode in Uganda and he has presented 4 sureties. The sureties are opposed only on the ground of their age being lower than that of the applicant, thus having no capacity to compel him to attend court. Rule 7 of this court's rules provides as follows: the court shall, before considering any person to stand surety for an accused person, determine that the person has the capacity, A, to influence and compel the accused person to attend court, B, to meet the terms of the bond. These rules thus leave the determination of capacity to compel the accused person to attend trial to the discretion of the judicial officer. The issue in contention is the age of the sureties, and I agree with the applicant's counsel that if court was presented with sureties above 69 years, then they would have so many health issues to advance for their failure to meet their obligations as sureties. The applicant has presented sureties not so young in age as at least being 41 years of age, and all have shown that they are gainfully employed, thus they can easily be traced. However, the relationship of most of the sureties with the accused would be enough to compel the accused to attend court. It is my considered opinion that the accused cannot see the son or his sister being remanded for his failure to attend court, and he sits back. I therefore find the surety substantial, as they have shown their capacity to meet the bond terms and can compel the accused person to attend his trial. On the issue of the applicant having another file registered in this court on charges of abuse of office, I'm cognizant of the fact that the bail guidelines implore us to consider this fact while granting bail. I have considered that the accused person is innocent until proven guilty, and being of advanced age of 68 years as stated in the charge sheet, I find that it is only just that he be released on bail pending his trial. I therefore grant the applicant bail on the following conditions: the applicant to execute a cash bail of 5 million shillings, the applicant's passport to be retained by the court as it was already deposited, the certificate of title in the names of the applicant comprised in block 24 plot 1406 at Bukoyo is retained as was already submitted as security. Each of the applicant's sureties to execute a non-cash bond of 50 million shillings. I so order.
I'm one of the lawyers that have been representing Sam Mugumya at Civil Division in an application for habeas corpus. Sam has been missing for now about 9 days, and we have information that he's being detained illegally and constitutional incommunicado at the CMY detention center that is ungazetted. Today we came for a ruling for the writ of habeas corpus, and the order was granted by the judge. We are very happy. Court directed the Attorney General, the CDF, and the police to have Sam brought dead or alive, his body brought dead or alive before court, or charge him legally within 7 days from today. That will be 12th. So we shall appear again on 12th at 9 a.m. for mention on whether the state has complied with this order and directive or not. But what I want to assure the Ugandans is that we are ready. We are going to serve the order on the respondents in this matter and ensure that they correspond and follow what court has directed. If they fail, we shall file an application for contempt, for contempt against this order. That's what happened today.
How do you reconcile two scenarios? The Constitution says a person must be accounted for within 48 hours. The judge is saying the woman should be accounted for within 7 days after his order. Of course, 9 days after his disappearance. What's your comment about that? Isn't this judge giving too long a period for a citizen? Yet the Constitution talks about 48 hours. Can a judge order a time longer than 48 hours for a citizen to be produced?
It is not acceptable, and I find it strange that instead of producing this body within 48 hours from the grant of the order, now we have 7 days. Much as we don't agree with that position, the law suggests and commands that the body must be produced within 48 hours. But nonetheless, we have the order. Let us follow the order even when we disagree with the days that have been set on which the body must be arraigned or brought before court. But we shall go with that one. Let us be optimistic that even before the 7 days lapse, we shall have Sam's body produced dead or alive.
And I am a good friend to Mugumya Sam. Even a day before he was arrested, we had been together because he was coming from Rukunjiri, where he has been having mobilization activities following his intention to run for Rukunjiri Municipality MP. So today we came here in this habeas corpus application. We are happy that the court has granted the application, although we would have loved that court demands that he's brought to court at least by like Monday. See, when we come to court for habeas corpus application, it is because we are concerned about a missing citizen, a missing person. We are concerned about what he's going through. We don't know whether he's alive, whether he's safe, whether he's eating, whether he's anything. And yet we have laws regarding detention, lawful detention. So we come here because we are seeing that the citizen is under unlawful detention. So ordinarily we would have been happier if the days within which he must be brought to court were fewer. Yes, today is Friday. We are now going in a weekend. We know courts do not work on a weekend. It would have been better if he was being brought to court like on Monday. Nonetheless, we are going to keep pressing. And we may not even wait for all the 7 days. Today, the time starts counting. The time starts counting today. If by Monday, Mugumya Sam is not brought to any court to be lawfully charged, we will be taking on other measures to enforce this order. Because 7 days is the maximum, it's not the minimum. So the state can even bring him, actually the state, it's now 3. The state can even bring him to court this evening and charge him, and then he starts to answer his charges. So we are 50-50. Happy, but still not yet very happy. But nonetheless, we hope that Mugumya Sam will be out. One thing I can tell Ugandans is that Mugumya Sam is innocent. He was only returning from Rukunjiri. He had returned to Uganda because he said, well, I am a Ugandan, I can't die in exile. I have an ailing mother. I needed to come back and take care of my mother, his mother in Nyakajeme. And that's where he has been. So it's so sad that the state decided to prefer charges against him.